Welcome to The Effective Lawyer, a podcast for ambitious attorneys who want to improve their practice. My name is Jack Zinda, and I'll be your host. Welcome to another episode of The Effective Lawyer. I'm Jack, and I'm here with our superstar, Allie. Hey, Allie, how are you doing today?
Hi, good. Thanks for having me.
Of course. Allie is captain of everything here at our firm. She has a role that is called integrator, and basically she's in charge of making sure the whole law firm runs correctly. She's also super busy with a newborn, right?
Yes, 9 months. It's crazy.
Wow. How's the sleeping going?
Good right now.
Yeah.
But I know that can change at the drop of a hat. So just riding that wave while I can.
You know, I've got teenagers. One teenager, 14 and 12, and it's a totally different ballgame. It got easy for like 3 or 4 years, like 8 to 10, like 6 to 10.
Yeah.
And then in the teenage years, it gets scary again because you can't really trust them. At age 12, I felt pretty confident, but now 14, I'm not as sure.
Yeah. All new adventures. Somebody told me once, small people, small problems, big people, big problems. It didn't make me feel good, but yeah, new challenges, I'm sure.
Exactly. And I got the kids to school on time every day this week.
Hey, and that's a win.
That is a huge win. Nothing is more embarrassing than getting that email saying that they were late.
Yeah.
It's like so shameful.
Because it's on you.
It's on me, exactly. Well, today we're going to take some listener questions and also some questions we get from other lawyers in the firm. And Allie's going to help us out and ask some of those. Yeah. So I have not read these ahead of time. Allie, why don't you ask away?
Okay, let's jump into it. Let's start with this one. I think that this is probably something a lot of people are thinking about with AI. If I plug client information into an AI tool, am I risking confidentiality?
The short answer is maybe, and you have to be really careful about that. OpenAI has a special platform that if you pay extra, it is HIPAA protected and then guarantee they will not use it to train their models. But if you just use off the shelf, they might. And if you also use someone else's product, you need to make sure that they're HIPAA compliant, they're SOC 2 compliant, and they have the safeguards to make sure that's not happening. It also could be a violation of attorney-client privilege and waive privilege in certain instances if you're not careful. So usually it should not, and a reputable company won't let it, but you have to be very careful of that, and buyer beware. There's a lot of people selling snake oil out there that it's just not good stuff, and they haven't done the proper protocol. So I'm very careful about that.
Yeah. All right, let's keep going on the AI topic. How about, do I really need to be using AI right now, or is it just hype?
I would say that's a really good question. And I hear something along those lines a lot. I think it's important to be testing it, but I don't think it's important that you have to use it in your practice at this stage. I would be experimenting with it, playing around with it, seeing how it could potentially help you. We have a team together that is trying to take simple use cases that we have and put them into AI to, make our firm more efficient. But I will say that it is a lot of overhype. There's a lot of things it can't do or can't do well. And the more complex the task, the worse it is at it. For example, if you say, hey, draft a brief for me, it's going to be terrible. If you say, write this small paragraph, it might be great. And also you have to be really careful when you're doing legal research. It will hallucinate cases. I know that's happened to a lot of people in court and they've gotten in trouble and sanctioned for that.
Wow.
And that's like literally just making up a case that doesn't exist.
Wow. And that's embarrassing.
It's really embarrassing. And you can get in trouble with that. I know a couple attorneys in federal court got fined for putting in bad citations in a case.
Wow.
But I do think like there's some ways you could start using drafting emails is a great way. We're experimenting with doing medical timelines, drafting demand letters. We've developed a way to do deposition summaries, but it took a lot of work. And there's not a lot of things off the shelf that can make that happen. So I would say, play around with it. I would get a subscription to all 3 different, agents out there. There's Anthropic, there's OpenAI, there's Gemini, are the 3 main ones that I look at, and play around with them. It can be also really great for marketing.
Yeah.
Doing images. Now you can do videos through Gemini.
Wow.
It can also, you can record stuff on video and ask it questions about it as well. I've used it to go through voluminous documents to try to find certain pieces of information, and it's getting better and better at that.
Yeah.
But I don't think it's at the point now you're missing out by not being involved. And in fact, if you get too distracted by the shiny object, you're not going to keep your eye on the prize of like making money for your firm and doing good legal work.
Yeah. What is one thing AI can actually do for me today that will save me time?
I will say, that's a good question as well. I use it a lot to draft emails. Like the first draft of emails, it's really helpful. Mm-hmm. I also think we've been playing with it to review resumes, not And you have to be careful about this because it'll have the same biases of, a human if you ask it the wrong question.
Mm-hmm.
So if I'm looking for an attorney, I might have it go through 100 resumes, say, hey, identify people who are licensed in Texas.
Mm-hmm.
But I would not tell it to find the best lawyer for us to look for.
Mm-hmm.
And unfortunately, right now, the job market is really tough for employees and people looking for jobs. So I know you are in charge of a lot of hiring. We've just been getting inundated with resumes on stuff.
Yeah. And it's definitely helped go through just volume for sure.
And it can be really time consuming to print each one out and go through each one individually. So that's been a big help. Another thing it can be useful for is trying to find names in Discovery, or trying to take, a page and kind of summarize it into a smaller piece. For example, if you have a crash report, trying to put together a simple summary of that. Also, it's getting better at looking at photos. I know Gemini is really strong. You can put photos into it and ask it to try to identify things in a photo or people in a photo as well.
Wow. I didn't know about that.
Yeah, it's pretty cool.
Interesting.
Yeah, there's so much you can do.
Yeah, that's awesome. Very cool. Okay, let's switch gears a little bit. Let's do case selection and strategy.
Okay.
What are the red flags that tell me to walk away from a case, even if the client really wants me to take it?
That is a great question. I will tell you, as a young lawyer, I see this is the biggest mistake a lot of attorneys make. Saying no to cases is just as important as getting the right cases. Because we work on a contingency fee, and this can apply to any practice, honestly. But if we don't win, we don't get paid. And when you first start out, you're usually desperate for business. You take a lot of cases that you might not take in the future, and you might take a lot of cases that are bad. The first thing I say is, if I really despise the client, I think they're a bad person, I don't think I can get along with them, I will reject the case. Mm-hmm. There's some rare exceptions. Maybe, they lost a child. Maybe it's just catastrophic damages. But for the most part, if I really dislike the client, I'll try to walk away, especially if I think they're dishonest or they've done something that I think is, unethical, that I couldn't agree to, that's part of the case. Now, it doesn't mean all of our clients are saints, but I use that as like one line. Two, if a client is disrespectful to our team in a way that's abusive. All clients get frustrated, they get upset. It's a difficult time, especially if something terrible happened. Say their spouse got killed. But when it crosses the line to abusive to our team, we make that very clear that that's not okay, because we want everyone to have a safe environment. So that's two. And what's key in these situations, I find, is make the rules ahead of time, because it's really hard in the heat of things to make a decision. And if everything's subjective, then it's tough to call a shot. And there's a thing called decision fatigue where, you're worn out at the end of the day. You just end up doing stuff that doesn't make sense. The other way you want to step away is if you cannot see a way to help the client financially. Our job as a trial lawyer, especially personal injury, is to help our client get money so they can pay for their medical bills and they can get a recovery for what happened. If you have a case where you don't think you can make a difference in the client's life, then you're not helping them either by dragging them along and, working, and it doesn't make sense. Then they're going to be disappointed and upset. And I found the clients that are the most upset are the ones that they're bad cases. I worked my tail off. We got a bad outcome, and they're upset because we didn't get what they wanted to out of the process. Another key point to remember is if the case doesn't meet your minimum threshold. I think that's really important to establish what is the minimum type of case my firm's going to handle. And in the beginning, it was one number. And then over time, it's increased 3, 4, 5 times. But every year we look at that again. And you want to stay true to that, because that's your, otherwise you become a volume practice where it's just volume. And then you can't do the great work that you really want to. So I'd say 1, if you have ethical issues with a client, 2, if they're abusive, 3, if the case doesn't meet your threshold. And I would say 4, if they're being extremely uncooperative. We have a process where if a client won't get back to us, we'll send, do some additional calls, send some letters. But if it's not a big case and they're not caring about it, I don't want to care more about the case than the client does. It needs to be important to them. And if they're not putting in the effort themselves, it doesn't make sense. And you actually get less money if you work on that case versus one where the client really needs your help and really wants it.
Yeah, that makes sense. How many cases can I really handle at once without hurting my clients?
That is another great question. That is different for every person. Our firm, we average about 25 cases per lawyer, and we work in teams of 2, and those teams will have 50 total cases. So there's two lawyers. Usually one's a lead trial lawyer, one's an associate. And we found 50 is a good number for us because of the amount of work we put into every file. From some law firms, I know some firms are primarily pre-litigation, or maybe they divide things between pre-lit and lit. I think in that instance, I've seen some lawyers handle, 75, even 100. I think that gets a little tight. And also, I want to know every file, I want to know every client. And I think you can tell when you're getting beyond your capacities. If you are not keeping up with deadlines, if you can't get back to clients. We have a 30-day rule and a 1 business day rule, which means we have to call the client back once every 30 days to give them an update on their case. And we have to get back with them within 1 business day. If you're not able to live up to those, you may have too many cases on file. And remember, if you have a case where you get $300,000 and you put a lot of work into it, or you have 3 cases where you get $50,000 because you can't put enough work into it to get to $300,000, you're in worse position there. And I think a lot of attorneys miss the point. And I see a lot of times where we'll get a case where maybe it was referred from another lawyer, or maybe they fired their attorney and they can't rebound the relationship. And they were leaving a lot of money on the table by not working the case up, by not finding the damages, not establishing liability. We had a case recently where they'd been in a firm and that law firm was trying to get them to accept a settlement of $35,000. They fired the firm, then they contacted us, and we contacted that firm and worked it out. But we ended up giving the client $2 million.
Wow.
And it's because we dug deep. We found a better source of recovery. She was still suffering TBI issues. And so you want to ask yourself, am I doing a great job on this case? Will this person get the best result from the work I'm putting into it? Or am I leaving stuff on? If I'm not doing a great job, do I not feel like I'm keeping up with my clients? If you're doing hourly work, it's a little more difficult to decide, but I think kind of the same principles apply of, can you get back to them? Do you know your cases? And are you pushing them at the pace you need to?
That's great. That's great. Kind of along that same vein, what's the biggest mistake lawyers make when they chase a big case?
I would say one error that I made a lot was offering too much in a joint venture with another law firm. Mm-hmm. Because for example, we'll split a case, 50-50 sometimes, 1/3, 2/3. But if you give away too much, you actually end up getting a lot less if it was a smaller case. That's one error I see attorneys make a lot. Mm-hmm. The second is being too aggressive to try to get the case to sign up. If someone was killed and say a family member contacts you, mm-hmm. you want to tread lightly in how you pursue that, because they're going through a lot. And you don't want to seem slimy or sleazy or pressure someone into a sale. And I find that the more you sound desperate, the more the client is less likely to sign up with you. Mm-hmm. So I see some attorneys that are over the top aggressive on things, and it comes across as weird and odd, and it makes you seem a little desperate. Mm-hmm. The other big error I see lawyers make a lot is not going to meet the person in person. Mm-hmm. We had a case we signed up a couple weeks ago where it happened in rural New Mexico, and one of the partners was Cole was on a flight over there within a day to go meet with the client. Wow. And she was really messed up, hurt very, very badly. And if we hadn't done that, I know the law firm would have gotten the case, would have gone seen them and gotten them there. Another mistake I see is not having someone who sounds the part, looks the part of an established lawyer if it's a big case. I'm not saying you have to be the oldest or look a certain way, but if you send someone that looks and sounds like a law clerk, they're not going to feel comfortable. Right? They're not going to feel confident in it. So 1, not going in person. 2, paying too much on a referral joint venture fee. And 3, sending the wrong person to go sign it up. And also you got to be aggressive. I remember a client one time kept emailing me, but would not give me her phone number. And we played email tag for 4 months. And it was a really big case. And finally, she reached out to me, and I was working for a guy at the time. He had kind of a weird way to pursue stuff, and he somehow back channeled and found her address, and he wanted to go to her house and just show up at her door. And I was like,
oh my gosh.
I was like, this feels creepy. And luckily I talked him out of it. And her and I talked on the phone, and we ended up signing up the case, but that would have been so odd. I don't think we would have got it if we'd done that move.
Yeah. Yeah. It sounds like there's a lot of, people intelligence that goes into that, being able to understand what people will respond us too.
Oh, 100%. Yeah, it is so much psychology. And it's weird. The more desperate you seem, the less likely you're to get the case.
Yeah.
I also find a lot of attorneys are bad about bragging on themselves. So I created a script that I give my lawyers, even the junior ones, to read that goes through our wins in a way that doesn't sound, arrogant or preposterous. It just is stating factually, we handle these types of cases. Here's some of the results we've gotten.
Right.
We also will tell them what to look out for in lawyers that they should not hire. Ones that don't specialize in this type of case or they don't try cases, things like that. So they know what to look out for there.
Yeah. That's awesome. Let's switch gears to case value and damages.
All right, let's do it.
How do you explain a TBI to a jury when the MRI looks normal?
I love working on TBI cases. They're some of the most rewarding. And they're a damage that you can't always see. And also, it's not always apparent even from how they're reacting to it. A lot of times a TBI can cause emotional issues, which recently with the NFL cases and the more we know about TBIs and concussions, people are now getting more used to that. But 4 or 5 years ago, that was considered odd. People didn't really understand how it could cause an emotional outbreak. Yeah. I remember we had a client one time who he had an amazing relationship with his wife. They've been married 30 years, had 3 grown kids. He was a great blue collar guy, and all 3 kids went to college, were, professionals. And he had never raised his voice at his wife ever in 30 years of marriage.
Wow.
And all of a sudden he gets this brain injury and he's yelling, he's throwing things,
wow.
And it was a total change in his personality.
Yeah. Yeah.
So a few tips on how to prove that to a jury. One, you can get imaging done that's called DTI, diffuse tensor imaging, which will actually show the parts of the brain that aren't functioning as well. And you need a special MRI to do that. So that's one option. 2, you get a neurologist or a neuroradiologist to explain why, even though the MRI looks normal, there still could be brain damage. And the literature has gotten very strong that, once you get a concussion, you're dealing with those symptoms forever, right. Potentially. And so what I like to do is connect the breadcrumbs. So first you see, okay, they had a wreck. How did the head get injured that caused the brain injury? So I want to explain that to the jury, and I want to try to show them how that occurred. The second piece I want to do is, where in the medical records does it say that someone had hit their head? Does it say hit on the dashboard, say hit the window? Also, side note, don't fall for the defense trick of hey, there's no evidence of it. Find out for yourself, look and see, the car. I had a case where a client hit on the side glass. The defense said that's not possible. They were wearing their seatbelt, but sure enough, it was cracked. And it was pretty clear. I've had situations where EMS did not note a head injury. Then I talked to the EMS person, and they say, yeah, she did have a head injury there.
Yeah.
Check the ER records, what the ER doctor says. Then after the ER, I'm going to, what are the things that family and friends are noticing that are different about them or their behavior? I think it breaks down into 2 categories. Usually it's cognitive. So their memory's not as good. Right. They're stuttering. Vision a lot of times is impacted by a TBI. We had a client recently that was having cardiovascular issues that was related to TBI. Wow. And you want to get credible witnesses that will testify, here's what they were like before and here's what they were like after. Then line that up with the symptomology that is in the neurology books that explains here is the causation. And you've got to have a doctor tell the story, in my opinion, to get full value in a TBI. Because if you don't, it's going to be really tough to have the jury understand causation. The other thing that you can do as well is get a PTSD counselor, someone who can help talk about the psychological impact. Now, you have to be careful if they had pre-existing mental health problems, because then that could make that admissible in the case.
Oh, right.
And also be careful about the type of therapist you might hire, because we hired one of the first cases I worked on. And for whatever reason, instead of talking about the traumatic event that happened, they got into her husband and her husband's drinking habits and
oh no.
And, I was like, this is so irrelevant, but it was in the record. So, it made it tough, and that was going to come in the case.
Right. Right. And is it relevant to whatever you're trying to talk about?
Exactly. So I learned the hard way that you want to make sure that you have someone that's specialized in TBIs and brain injury cases. So, step one, check the ER records, EMS records. Step two, ask your client what they're going through, what they're seeing, feeling, hearing. And I'd also yourself get familiar with the literature on what the symptoms are on that. Because a lot of times the doctors won't even look for it. The client's telling you about it, and you have to make sure you recognize it and say, hey, why don't you go see a neurologist to see if there's something more going on here? 3, look at getting a DTI. 4, before and after witnesses. And 5, having a doctor tied all together.
Yeah. That's awesome. What is the best way to prove future damages when the client looks fine on the outside?
Another great question. I love these damages questions. I think they're so much fun. That's also why I love what we do. I look at my job as to tell the truth. And so I start with, do I believe in these future damages? I remember I had a case one time that one of our attorneys was working on, and it was a child was hurt and they were like 2. And the therapist said they were going to need therapy every week until they were 18. And it just sounded ridiculous.
Yeah.
It's like a 2-year-old, they were hurt. Are they really going to come every week until they're 18 years old about this thing that happened when they were 2 years old? No, it sounded so silly.
Right.
I was like, we can't use this. This is crazy. So first I asked, okay, does this pass the smell test? And then you actually got to know the medical literature a little bit, because you have to understand, like, how could it be caused by this one way or the other? The second is you need to have credible witnesses that can talk about what they went through in the symptomology. So, for example, if you have a wife, their husband is probably the least credible person besides themselves. Now, their supervisor at work, that's a very credible person. They could talk about what they've seen them go through. Also, imaging is really helpful. If you don't have images like x-rays, getting images of what the type of harm looks like as a demonstrative and having a doctor explain it. So if they have a herniation, having the doctor show how that could cause tingling in their legs through the nerve damage, which then can make it difficult for them to walk, which then would be very painful. And I try to pull out as many details as I can from the testifying doctor to explain what it feels like. Does it feel like, glass going across their skin? Does it feel sharp? Is it electrical? Does it burn? What's the sensation? Because you want to bring it to life to the jury. And I'm a big believer in visuals and primacy. What does primacy mean? That means just people believe what they see first. So that's why credibility is so important in a case. So if the jury believes me and trusts me, and then I'm telling them a story and I show them a picture about the harm, and I say what the harm means and how it affects them, and then the doctor backs me up, they're going to remember that as if it's a fact that no one's contesting. Now, if I don't have credibility or the client does it, I'm in trouble.
Right.
That's why you have to also discard anything that kills your credibility. We do that a lot if it's a loss of earning capacity claim where, maybe the client didn't file their taxes, or maybe it's a little bit of a stretch. We don't claim that because it's going to create more harm, and now the client's not credible. So a lot of times we'll nix anything that doesn't make sense. And I think you always need to have a doctor testify to what the future medical care is going to be. And we usually try to find somebody who, it could be their treating provider, it could be the neurologist, that understands the medicine and can communicate it well to a jury, because it's all about credibility. And then also sometimes we won't have the client at trial.
Interesting.
Yeah, well, actually we have to, work down on that with the jury. But if you have someone that has a TBI, they're going to be staring at them the whole time. You're like, well, they didn't look hurt, or they laughed. Why did they laugh? That's weird. They don't seem that sad. And we've gotten some really great results without the client there. But you have to be careful. It's kind of a case by case situation.
Right. I actually just had this question too while you were saying that. Somebody wants to know, when a treating doctor doesn't want to get involved, how do you still get their story in? Oh man, that is the worst. I've had so many doctors who do not want to testify. I remember one of my first cases, our client went to an orthopedist that was covered through the health insurance. And the doctor put in the records, I think they had gotten sued for malpractice or something to someone, because they really hated personal injury lawyers. Wow.
I tried to call him up and he said $10,000 an hour.
Oh my gosh.
A minimum of 8 hours. So obviously he didn't want to testify.
Yeah.
And then he also put in his records, the personal injury lawyer called me to ask me to testify.
Oh, great.
Which was just like, it was terrible. But anyways, that doesn't happen very often. The first thing is you can have another expert witness rely on the medical records of that doctor to testify. I personally, I don't like dragging people there against their will, because who knows how they're going to react. Also, they may not be credible. or they may be credible. They just may sound bad in front of a jury. But sometimes those make the best witnesses. I also may call them up and explain the situation or have the client contact them for me. And you want to be careful how you explain it. So I'll say something along the lines of, I know you're treating Jane Doe. And as you and I both know, she's such a sweet woman. She's been going through hell with this incident, this accident that happened. She's missed a lot of work. She's in a ton of pain and we're trying to help her. And unfortunately, the insurance company says that you're a quack and I mean, not say quack, but like that she's not really hurt and doesn't believe what you're saying. And is there any way you'd be willing to help us out and testify? I wouldn't actually say help us out. Would there be a way you'd be willing to testify and tell them what happened? And we just want you to tell the truth. That's it. I'll be very respectful of your time. I'm willing to meet you any time or day, to try to see if you can get them to come and talk to you in a deposition. And if they won't, then sometimes we'll hire an expert just to review the records, almost like a second opinion. Then they can testify as to what happened with the client.
Oh, awesome. How do I handle it when the defense lawyer is more experienced than me?
I dealt with this question just about every case, like the first 12 years of my career. The first firm I was at, I was actually hired to start the PI practice, which was crazy because I was right out of law school and every attorney was like 20 years older than me.
Wow.
And they all knew it and they all tried to push me around.
Yeah.
So step number one is be confident, don't be cocky, and don't back down. There's also, you can go too far. I call it kind of the yappy dog syndrome where you're so aggressive, it's obvious that you're scared. Mm-hmm. And you're just like fighting for no reason. Mm-hmm. The second is know the law. I was amazed by how many experienced attorneys do not know the law.
Right.
That's like a superpower. And if let's say you're in a deposition and the defense attorney is objecting, and they're not allowed to, they're doing speaking objections. If you cite the rule for your state and say, hey, this is against the rule. I've said it 3 or 4 times. I'm going to suspend the deposition if you don't stop. All of a sudden, like, whoa, okay. And I kind of look at like, you want to keep them on a short leash. You want to be professional, but know the law. That's one. 2, show them you know what you're doing early on in the case. A lot of times I'll call the defense attorney just to talk to them when the case starts out. Yeah. And get to know them a little bit. And then you may also put things on your website that show you're very experienced. But I think no substitute for knowing the law well and being confident. And you can also go get that attorney's depositions. I did that early in my career. I'd go find copies of depos they had taken. I would talk to my colleagues that had been up against that lawyer before to find out what their tactics are. And unfortunately, some of them have the same MO where they try to do kind of like shady things or try to push you around, and you know what they're going to do if you know ahead of time, and you can be prepared for it. Also, outwork them. I mean, if you outwork them, you know the law better, you'll be fine. And don't be afraid. I mean, rarely does experience equal greatness. It can sometimes, but sometimes they've just been doing the same things wrong forever. Right.
I'm going to go off script, but only because you kind of jogged another thought. You've spoken a lot about knowing the law and knowing the literature for TBI. If you're a new attorney, I'm sure that's got to be very overwhelming. Where do you start? What would be your recommendation?
I would start really simple.
Okay.
Honestly, I had a medical dictionary and I would just, every time I read a medical record, I would circle the words I didn't know and I would look it up. Then get a primer. Like there's these great CLEs that are the cross between an injury type and the law. AAJ has a brain injury section. Mm-hmm. And if you join AAJ, it's like $300 to be a member of the brain injury group. And there's great CLEs on that topic. And also just start with the basics. Like you don't have to know everything. So you say, okay, what is the mechanism of harm of someone that has an injury? Where would I find that out? So I might go to first a medical dictionary to look that up. Then I might see if there's like an article someone wrote on how that causes the injury. Mm-hmm. Then I might say if there's a CLE article with AAJ, the brain injury group. Then I might see if there's a book I could buy. But don't stress yourself out. I think a lot of the things we do, you want to get a baseline knowledge. So the way I like to learn things is I will dive deep and kind of go through all the materials one time. Mm-hmm. Then I'll know where to find the information and come back to it. I used to stress myself out by trying to remember everything.
Yeah.
And then when I realized I don't have to remember it, I just have to know where to find it.
Right.
Then I can come back to it and identify it. The other thing is, and this is a big mistake I see lawyers make, is be modest. Ask a lot of questions. When you're talking to their doctor or the expert, act like a novice. I still do that in cases. I think I know a lot about trucking. I think I know a lot about brain injuries, but I will ask rudimentary questions just to confirm I'm right. And I'll be surprised. I learn a lot of things that way.
Wow. Yeah.
But if you're too egotistical to act like you have a question, you will not learn.
Right.
And it's also a great way to get free information and learn from an expert actually how these things work.
Definitely. Awesome. Let's go to settlement versus trial.
Okay.
Yeah, I think we haven't touched this part yet. How do you know if a settlement offer is the best the defense will ever give you?
That's another great question. And this is a very difficult thing to figure out. First, I would not let the defense be in charge of how much you're going to take. I would decide what the number is for yourself and make that your bottom line number. The one reason why people undervalue cases is because they're not confident in their number and they don't know how much it's worth themselves and how much to ask for. So first, I would shift your mentality from how much is the defense willing to pay to how much am I willing to take? Then a lot of it's going to depend on your opponent. If you're new to the practice and you don't have a reputation for trying cases, you're going to have to push it much further than if a more experienced attorney who they know is going to try cases. And once you've proven yourself that you will take a case to trial, you'll get better offers earlier. The second is obviously if it's policy limits, that's the most you're going to pay.
Right.
I have found rarely do people offer serious money in a big case early in the case. And if they do, it's usually a much better case than I know because they're trying to hide some information. So I would take that as a sign that they have a lot more to offer. Also, I find in a big case, rarely will they pay you full value pre-litigation. I think it's always on the side of the defense to delay. Your client could die, they could get arrested, they could get divorced, they could get another wreck that screws up your medical record. So things could always get worse in their mind. So they're trying to delay things to try to get the most money available. Also, if you get to know the defense attorney well, they'll share information with you to try to kind of, figure out what the value is. The adjusters are motivated by not getting fired and to not get embarrassed at trial. So they get fired if they tell their boss that the case is worth 100 and they end up getting hit for $1 million verdict. So showing how much the case is worth, talking to the defense lawyer, find out what the insurance adjuster might have is a great way to figure that out as well. And it just takes time to be good at that skill.
Yeah.
But I really go back to the idea of figure out what do you think the case is worth. You can do focus groups. You can look at jury research. You can ask other attorneys. We roundtable cases and we will go through each line of the charge and each attorney that has experience will go through what do we think a jury might do, best day, worst day. And then we'll kind of look at all the numbers on the board and see, okay, what is a fair number now versus at trial? And we'll subtract out expenses and if the fee's going to go up, that sort of thing. But you can make it a process and make it a process for yourself and then just refine it and make it better and better.
That's great. When is it worth turning down a sure thing and taking the risk of trial?
Well, in any case that you're getting an offer, that's a sure thing, right? I ask myself 3 questions. One, is this number within a range of what a jury would give? 2, would this money make a meaningful difference in my client's life? And 3, well, I think maybe that's only 2 questions to ask. I thought there was a third. Maybe it's, I know the big ones are, would this make a meaningful difference in the client's life? And then is this within the range of what a jury would give? And why do I ask those 2 questions? Well, one, if they offer you $1 million and the client has $900,000 in medical bills, that's what we call a zero offer. If they offer $1 million and the client has $10,000 in medical bills, well, that's going to be a lot of money in the client's pocket. So the first thing is this going to be a meaningful difference in their life? And it doesn't mean the size of the case. It could mean, am I making a difference for them? Sometimes you have really tough cases and getting the medical bills is like a good victory, but that's rarely the case. And also, what is the range of jury we give? And then I will subtract out the amount of expenses that I'm going to have to put into the case because that's coming out of the client's settlement. And so you're going to discount it slightly than what you would take from a jury at trial. And then you have to bake in the risk. And always remember, if you have a case where you could get 0, make sure that the client knows it if they're turning down a reasonable offer. If it's a slam dunk liability case, that's one thing. But if it's a chance they could get zero because it's, 51-49 the other way, you have to make sure they're aware of that so they don't make a bad decision.
Yeah, definitely.
Great questions.
Last one. How do I manage a client who wants to settle cheap because they're tired of the fight?
That happens a lot as well. One, push your cases aggressively.
Mm-hmm.
The longer you take, the worse it is on your clients. Mm-hmm. So I think that's mistake number one. If, our average time to resolve a case is 12 months. And that means these are cases we're litigating because we're very aggressive. It's a big case. We get into litigation right away. We do not like to give extensions on expert designations or discovery deadlines. So that's step one. Don't stretch it out. Step two, you want to make sure you're educating your client along the way about what the outcomes could potentially be and prepare them for the numbers that are going to come down the system. And make sure they're aware, like, you can always accept this number later. It doesn't mean we're turning down now that you can't get it later on in the case or right before trial. As a lot of experienced trialers know, a lot of times the case settles in voir dire or settle an opening statement, and rarely does the defense ever go down from their last offer. And if they really, really want to settle, you have to obviously do what the client says, but make sure it's for the right reasons. They really understand the risks. And do they know what the net is going to be to them at that number? I see a lot of attorneys, they make the mistake of just talking about the top line number when they're talking to the clients. You have to talk about what's the bottom line number. What are they going to get? And if they're getting very little money, they may change their mind, change their tune.
Mm-hmm. Mm-hmm.
And every circumstance is different. We had a case where a client really needed to move overseas. And, it wasn't a massive case. And so to them, it wasn't worth sticking around in the States longer to get to the trial. Other instances, they're just scared. And so you might also explain, this is not a scary process. I'm going to be with you at trial the whole time. No one's going to yell at you. I'm going to make sure you're protected. And that may also help them calm down as well.
Yeah, I'm sure. Okay, let's do a couple more if you're up for it.
Yeah, let's do it.
Okay. Let's head over to depositions and witnesses.
Okay.
What's the number one mistake that trips up lawyers in depositions?
I would say if you're a new lawyer, backing down from the defense and letting them talk over you, do running objections, or bully you. And so to prevent that, you need to know the law and know how to defend against that. Every state and federal court has rules about what you can object to, what you cannot. And I would also recommend, instead of calling the judge, suspend the deposition, because you don't want to, in my opinion at least, I don't like bothering the judge. And also, you don't want to ask questions if they're going to keep doing speaking objections, because they're going to get a free peek of what you're going to ask them. And that's actually a tactic. And then they'll come back. They'll actually know what the question you're going to ask and be prepared to handle them. Mm-hmm. The second mistake I see lawyers make a lot of times is they did not think about what they wanted to do in the deposition. They just wrote down a list of questions, or they have what's called like an outline, where they just took someone else's outline from a similar case and just followed that script exactly. There's a really great book by Paul Skofter that goes through deposition preparation and deposition questions to ask. And it really changed my mindset from being, outline focused to objective focus. So I'm trying to establish liability. I'm trying to get them to agree with some of the harm that was caused. I'm trying to establish that they broke rules or regulations. And going into that, I'm kind of following the path where those go. And then follow the openings that they give to you. Don't just stick to your script. Follow that hole that you're trying to scratch the itch on the logic. Another mistake I see lawyers make is they rush themselves. There's a lot of power in silence. And there's nothing more awkward than you sitting there, which I love. And you're just taking notes, thinking. Everyone wants to say something. They're just they cannot stand it. And they'll just reveal something. Yeah. Opposed to you rushing, you're apologizing. And then you don't get to what you wanted to get to.
Mm-hmm. Mm-hmm. Those are great. What's the one question I should never forget to ask in a deposition?
That's a tough one. I always think it's important to ask if they're on any medications, I know it's kind of a dumb one, but what did they do that on before? Any medications, alcohol, things like that. If I'm doing a fact witness, I always like to make sure I ask everybody they've been in contact to is related to the case. Man, that's what one question. That's hard. I would say the drugs and alcohol is important, who they've talked to. Have they taken a deposition before? Can they hear you?
Yeah.
It's funny, you'll be surprised. I've also had people fake not being able to speak English. in depositions.
Wow.
I also had one time more than one time, the person was mistranslating the depo.
Wow.
I'm semi-fluent in Spanish, and he was saying, I don't know, instead of like, I don't remember, which are different answers.
Yeah.
And it's because a lot of times the person translating starts empathizing with the person, is trying to kind of help them out because they think they didn't understand the question or something.
Mm-hmm.
So I always get the transcripts checked for the translations now. That's not really a question, more of an observation.
Yeah. That's interesting. How do I stop a defense witness from running away with the deposition?
You want to take charge. And if you have to, explain what you're doing and that they have to answer the questions that are being asked, and object to non-responsive. But you want to keep them on a tight leash if it's to your benefit. Sometimes them going on and on is great and they're just telling you stuff. And then sometimes they're smart. Like I've had corporate rep witnesses, and especially experts, where they know what they're doing and they just will talk over you because they want to try to eat up the whole 6 hours, so you can't really get good stuff out of them. And then if you think it's the case, call them out for them. It's like, Dr. Smith, as you're aware, I only get 6 hours for this deposition, correct? Correct. And you keep talking. I'm asking you the questions, yes or no, but you're giving me a 10-page answer. Are you aware of that? Yes. Okay. Can we agree that you will answer the question I'm asked so I can get all these questions in? And if they keep doing it, show that to the judge and say, I need more time, Your Honor. And then ask for your attorney's fees to be paid, because it's a game if it's an expert witness like that.
Wow. Yeah. I think that wraps up most of the questions that we have for today.
That is every question anyone ever had.
Yes.
Well, this has been fun. Thanks to everybody who submitted these questions. Thanks, Allie, for coming and helping out today.
Yeah. Thanks for having me. This was great.
And until next time, thanks.
Thanks.
That wraps up another episode of The Effective Lawyer. Don't forget to subscribe so you never miss an episode. And if you've got a minute, a quick rating or review goes a long way. Want more tips, insights, and stories from the field? Head over to zindalaw.io to learn more. Thanks for listening. Until next time.